Hello and welcome to the Goldwater Institute special teleforum event featuring Peter Wallison, Senior Fellow at the American Enterprise Institute, Timothy Sandefur, Vice President for Litigation at the Goldwater Institute, and John Riches, Director of National Litigation at the Goldwater Institute. Before we kick it off, I just want to remind our guests that if they do have any questions, go ahead and submit those questions to events@goldwaterinstitute.org. And with that, I'll go ahead and turn it over to Timothy Sandefur.
Thanks so much, and welcome everybody to talking about what I think is an issue of great importance nationally. It's something that ought to be of great importance to people in any political party, whether Republican or Democrat, and that is the growth of unelected administrative agencies and the expansion of their power, and what can be done to ensure that these agencies abide by the law and that they respect the democratic process. And so these agencies tend to be staffed by hired officials who are not, in any really realistic sense, answerable to the elected officials who in theory oversee them. So we wanted to talk today with Peter Wallison, who is the author of this recently published book, Judicial Fortitude, The Last Chance to Rein in the Administrative State, published by Encounter, and with my colleague John Riches, who you might remember a couple months ago, John and I did one of these teleforums about a little paper that we put out about reining in the administrative state. So I wanted to start off the talk, Dr. Wallison, by talking about one of the overriding themes of your book, which is the separation of powers and the risk the administrative agencies pose to the constitutional scheme that our founding fathers created.
Yes, well, that is the fundamental issue that I tried to deal with in that book, because we are headed for a time, and I'll talk about this when I deliver my prepared testimony or speech. We are headed for a time where most of the laws in this country are going to be made by these faceless bureaucracies that surround Washington, D.C. And how Americans will react to that is the question. I'm quite concerned that they will react by losing confidence in their ability to control their own government and thus challenge the legitimacy of the United States government. That's what happened in Brexit in England, when they were getting a lot of new regulations from Brussels that they had no control over. And so I'm a little afraid that we're headed in that direction unless we take some action soon.
You said you had some other remarks. Tell us what you have to say.
Okay, can I start?
Please.
All right. One of the most important issues facing this country today was not on the ballot on Tuesday. It's the question of whether our laws will continue to be made by Congress, as the Constitution requires, or by the administrative agencies of the executive branch, which is often called the administrative state. Indeed, the first line of my book, Judicial Fortitude, is this: it is not too much to say that we risk our democracy, we risk losing our democracy, unless we can gain control of the agencies of the administrative state. Rulemaking by unelected officials with little congressional or judicial oversight affects the lives of all Americans in very profound ways. But we have failed thus far to develop any effective strategy for controlling it. In the last few years, conservatives on the Supreme Court have begun to focus on a way to limit regulations. But the Supreme Court has to wait for a case to arise that will allow the court to make some kind of new law. Even then, the opposition will be substantial, and the court could reverse course if it fears a serious political backlash. As we all learned in civics, the U.S. Constitution creates a government of separated powers. Congress makes the laws, the executive branch enforces the laws, and the court system, the judiciary, headed by the Supreme Court, interprets the laws. Each of these sectors is required to stay within its prescribed lane and not trench on the turf of the others. Now, why did the Constitution's framers create such a complicated system? According to their writings in what are called the Federalist Papers, articles written mostly actually by James Madison and Alexander Hamilton, to persuade the people at the time to ratify the Constitution, the framers believed that the people's liberty would be in danger if the same group or person had both the power to make the laws and to enforce them. In Federalist 47, for example, Madison said, "There can be no liberty where the legislative and executive powers are united in the same person or body of magistrates." To prevent this from happening, the framers gave the judiciary, that is the courts, the exclusive power to interpret the Constitution and laws. So if the other branches began to move outside their constitutionally defined territory, the judiciary would be able to step in and sort of right the ship. In Federalist 78, Hamilton said the courts were the guardians of the Constitution and were given life terms in office so they wouldn't fear taking on the more powerful elected branches. "It's easy to see," he wrote, "that it would require an uncommon portion of fortitude," and that's why my book has that word in the title, "in the judges to do their duty as faithful guardians of the Constitution if either Congress or the executive branch were to violate the Constitution's provisions." The framers thought Congress would be the most powerful of the three constitutional branches, and they were correct, at least for the first 150 years of this country's history. However, things began to change in the late 1800s with the development of a bipartisan progressive movement headed by Woodrow Wilson and Theodore Roosevelt. Economic growth after the Civil War had resulted in the development of powerful financial and business enterprises, especially the railroads, and heavy immigration from the South and Europe produced widespread poverty in the cities. The progressives wanted the government to bring these problems under control through regulation of the economy. The speeches and writings of Wilson and Roosevelt made clear that they favored major changes in the constitutional structure. Their objective was flexibility, a constitution that would change as the problems of the country changed, and they believed that the framers' constitution was too rigid to meet this test. Wilson called the government a living thing, anticipating what today's progressives call a living constitution, the idea that the Constitution could and should be changed by judicial interpretation or congressional action as the views and moral sentiments of the American people evolved. This idea still animates the progressive or liberal movements in the United States, while conservatives, especially those on the Supreme Court, have moved in the other direction, favoring the interpretation of the Constitution according to its original meaning. The progressive solution to the country's problems was to create agencies with specific responsibilities for regulating or supervising various sectors of the economy. The progressives' ideal is that the economy would be guided by disinterested experts, university trained and credentialed. They would diagnose and treat the problems of these powerful conglomerations of business and finance, low wages, long hours, unemployment, labor conflict, deflation, and many, many more. Finally, in 1887, Congress established the first major regulatory agency, the Interstate Commerce Commission, to regulate the railroads, and this was followed by other government agencies such as the Food and Drug Administration in 1906, the Federal Reserve in 1913, and the Clayton Antitrust Act in 1914. However, none of this government growth approached what happened after the Franklin Delano Roosevelt in 1932. At that point, an intractable depression, combined with a rebirth of progressive power, resulted in the creation of many new administrative agencies. Not only were more powers given to cabinet agencies like the Department of Commerce, Labor, and Health and Human Services, but many independent agencies like the SEC, the FCC, and the FTC were also created. These agencies were then empowered to issue regulations that were binding on Americans, in other words, laws. Now, how can that be? Constitution says that only Congress can make a law. How is it that these agencies, part of the executive branch, were able to issue regulations that had the same effect as laws? If this had continued, it would create exactly the problem that Madison had warned about. The executive branch would have the authority both to make laws and to enforce them, a clear challenge to the framers' purposes in separating the legislative, executive, and judicial powers. Finally, in 1935, the Supreme Court stepped in, declaring in two cases that Congress had unconstitutionally delegated to the president the legislative power that the Constitution had reserved for Congress. However, in 1936, FDR won a smashing electoral victory, and the Democrats gained massive control of both the House and the Senate. To punish the court for declaring his initiatives unconstitutional, and not only those two, but many other cases that were questioned by the court, FDR proposed a court packing plan to Congress that would have allowed him to appoint 7 additional justices and thus given him control of the court. Fortunately, the public opposed this idea, and it did not pass Congress. But the episode proved that Hamilton was correct. The court needs a lot of fortitude to challenge one of the elected branches. And in truth, that court didn't have it. Soon the court began to reverse itself. The justices of 1935 began to retire, and FDR actually did have the opportunity to appoint all the members of the court by 1941. The justices he appointed approved virtually all of the New Deal activities and established precedents that have prevented the court from challenging the powers of the administrative until today. One important decision in a case called Chevron versus Natural Resources Defense Council, adopted unanimously by the court in 1981, declared that lower courts must defer to administrative agencies' interpretations of those agencies' powers, if that interpretation was, quote, reasonable. This case is one of the most cited of all cases ever decided by the courts and has immeasurably increased the power of the administrative state. With the ability to interpret how much authority they have been given by Congress, administrative agencies have continued to grow in number and power. There isn't any reliable list of the thousands of agencies that currently exist. We do know, however, how many rules and regulations they issue. Wayne Cruz of the Competitive Enterprise Institute did a first census of the rules of the agencies in 1903. And he continued that through 2018 and found that there were well over 101,000 rules and regulations that had been produced by the agencies in only those 25 years. That amounts to about 3,000 regulations every year. So it's easy to see that the real lawmakers in the U.S. government are not members of Congress, as the Constitution requires, but the thousands of large and small bureaucracies throughout the executive branch. And if this growth continues, it won't be long before the American people will see that elections don't really change anything, because the laws are being made and enforced by a faceless bureaucracy that no one can control. This will be a very dangerous moment for this country. Think of what happened in Brexit. as I mentioned before, the nickname for Britain's decision to leave the EU. There were many reasons for Brexit, of course, but one of them was that the Brits had concluded that they did not have any significant ability to control the hundreds of regulations that were coming out of Brussels, where the EU is located, and were immediately binding on them with no action by their own parliament. The result was the EU's loss of legitimacy among the people of Britain and their corresponding vote to leave. If nothing is done to rein in the agencies of the US administrative state, over which the American people probably already believe that they have no control, the US government will lose its own legitimacy. If that happens, Americans will no longer agree voluntarily to obey the laws, which is a disaster for any political system, especially one that claims to be a democratic republic. Therefore, a way must be found to rein in the power of the agencies of the administrative state and return the lawmaking power to Congress. Only then will the American people believe and agree that they have control of their government. Fortunately, there is a way to do this. The principal reason that so much power has flowed to the administrative state agencies is that Congress has been afraid to make the tough decisions that are part of legislating. Instead of taking these difficult votes, Congress has been setting goals for the agencies, such as achieving clean air or clean water, without deciding who will actually have to pay the price for reaching these goals. In the end, this means that the members of Congress are not accountable for what the agencies do, and their constituents find that they can't hold their elected representatives accountable either, because when they complain, they are told that an administrative agency has made the rule, not their elected representative in Congress. So what is necessary is something that will force Congress to make the tough decisions for governing society that a legislature must make. A few minutes ago, I mentioned two 1935 cases in which the Supreme Court had declared presidential action unconstitutional because, in the court's view, Congress had delegated its legislative authority to the president, even though the Constitution says all legislative authority is vested in Congress. Given the framers' view that the separation of powers is essential to maintain the people's liberties, that sentence must mean that Congress cannot delegate its legislative responsibility to any other constitutional branch, including, of course, the agencies of the executive branch. This idea is called the Non-Delegation Doctrine. Aptly named, but a little awkward. And at least 5 members of the current Supreme Court have stated in opinions that they are willing to invoke the non-delegation doctrine whenever they have the appropriate case before them. If this occurs, it will immediately force Congress to begin taking its legislative authority seriously. Otherwise, the law they pass will be declared unconstitutional by the Supreme Court. In other words, Congress will have to specify more exactly what authorizes a particular agency to do anything. And the agency will not have the discretionary authority to go beyond what authority Congress has specifically provided. In my view, if the Supreme Court does not invoke the non-delegation doctrine in this term or the next few years, we are looking at a future in which Congress will be irrelevant, and where all the rules Americans have to obey will be made by unaccountable administrative bureaucracies that are in and around Washington, D.C. Thanks very much.
You know, what you said about that, it certainly brings to mind a lot of what we've been seeing in the past couple months with regard to the shutdowns and government regulations of businesses in light of the coronavirus pandemic at the state level. We've seen governors issuing orders, Pennsylvania, California, all sorts of states, and these go beyond simply, emergency measures to protect the public, but actually setting rules. We've seen some state courts invoking the non-delegation doctrine. The most obvious one is Michigan, which just decided the Michigan Supreme Court just recently decided a case on that subject. So it's nice to see that the non-delegation doctrine at least lives in theory in some areas. And one of the things that we're interested at the Institute is the state level concerns that are often overlooked when we talk about federal agencies. So I think a lot of what you say has a lot of relevance to state level bureaucracies too.
Yes, that's right. In fact, I have another book I'm working on now, which will contain essays by 10 well-known legal scholars. And one of them is going to be, will be a paper talking about the non-delegation doctrine at the state level. And the states have been very active in this area, and there might be some lessons there at the state level for the federal government.
John, this is kind of our area and the issue of state regulations. And what do you think you've read the Michigan opinion and you've seen that decision that came just the other day from the trial court in California on that addresses non-delegation and so forth. What do you see as the hope for not just about the pandemic, but just generally administrative law at the state level as far as these things are concerned?
Well, I think up to now, I'm sorry, were you?
No, I'm sorry, go ahead.
Right now, I think although there have been cases at the state level, they have not been widespread, at least according to this paper that we've received for the book that I'm preparing. So in some states, it has been used effectively, but then forgotten, it seems. And 20 years later, when they had an appropriate case that would have been suitable for the non-delegation doctrine, they let it go. But I think if the federal government and if the Supreme Court begins to take this seriously, I think the states will follow very quickly, because actually they've been operating in an environment where they've had no support from the federal government. The Supreme Court after 1935, 1936 just gave up for fear that there would be a packing of the court, I guess, and decided not to interfere with whatever the federal, mostly the president was doing. Different court now, and there are now 6 members of the court who have indicated very clearly that they're looking for a case where they can just advance the non-delegation doctrine. And I think...
Are you optimistic about the opportunity of non-delegation at the state level?
Am I optimistic about the state level or the federal level?
Well, let's see what you think about either one, and then we'll turn it over to John.
Well, I am optimistic about the state level after the federal level operates. Once they get a signal from the Supreme Court that this isn't a wild-ass idea, but something that fits in with the usual constitutional structure, the state constitutions are very much like the federal constitution. They have many of the same words, and they generally use the same concepts. And if the U.S. Supreme Court says, if you have something in your constitution that says that the laws must be made by the Congress or the legislature, and most state constitutions have something like that, if that's true, then you've got to enforce those laws, because we were founded by people who believed that it was very dangerous over time to have the laws both made and enforced by the same group. So I'm hopeful, because I know that at the Supreme Court, I don't know where Amy Coney Barrett is on this, but she's conservative. She says she's an originalist. I suspect she will fall right in with the 5 other members of the court, the conservatives on the court, that have begun seriously talking about this. And it was only actually the delay in confirming Kavanaugh that kept the court from making a decision on a case that was before them in 2019, I guess. The so-called, the Gundy case, the so-called Gundy case. It was a perfect case for non-delegation, but unfortunately Kavanaugh hadn't been confirmed by that point. He hadn't taken the oath, couldn't participate in the case. And under those circumstances, they only had 4 votes, and they decided not to move on that.
All right, let's bring in John. What do you think, John?
So I think one really interesting phenomenon that has been working perhaps in the opposite direction, where the states may be moving the feds, or could conceivably be moving the federal courts and the federal Supreme Court, is this area of deference, which Peter talked about. So Peter described a system where administrative agencies are the rule makers. They make the rules. They investigate alleged violations of their own rules with their own investigators. They adjudicate alleged violations with their own administrative law judges, who are often employed by the agency. And then, to add yet another wrinkle, when and if that decision from an administrative agency is appealed to an actual court, an actual supposedly impartial court, whether it's a federal court under Article 3 or a state court, courts, because of the decision that Peter mentioned, Chevron, Auer, and a couple other decisions, are obligated to defer to the agency's determination of disputed questions of both fact and law. What that means is that if you are a regulated party and an administrative agency says, I think you violated statute X, and you say, no, I don't think statute X says what you think it means, courts at both the federal and the state level are obligated to put a thumb on the scale for the administrative agency. Now, of course, that raises this structural, probably compounds the structural problems that Peter was talking about. Why does the government get an advantage over any other party before a judge? But it also creates an accountability problem for the agency itself. Look, if you're a regulator and you're in a position where you make the rules, you investigate the rules, you adjudicate the rules, and then if somebody challenges that adjudication, you get basically an almost free pass from the courts. What's going to happen? Naturally, what's going to happen is there's going to be more rulemaking, more arbitrary government, bigger government, more invasive government, and more rules in areas that perhaps the government should never be involved in the first instance. So like Peter, we looked at this problem, and quite obviously it's a problem at the federal level. That is perhaps the biggest problem, but it is also a major problem at the state level. 36, by our research, 36 states have adopted some version of either the Federal Administrative Procedures Act, from which this deference doctrine has been divined by the courts, or state courts have applied some deference doctrine just on their own through their own decisions. So when we looked at that, we go, well, that's interesting. There could very well be a state solution. And of course, we've seen state courts, the state court in Wisconsin, the Supreme Court in Wisconsin, the Supreme Court in Mississippi, which eliminated this deference doctrine judicially. But it also occurred to us, because these statutes are often based on the federal statute and they exist in state law, well, why don't we just go into state statute and add a very simple provision, which is precisely what we did here in Arizona, where we dropped one sentence into the Arizona Administrative Procedures Act, which says, in any proceeding brought by or against a regulated party, the court has to decide all questions of law, including interpretations of rules promulgated by an agency or any constitutional questions, without any deference to the decision that was previously made by the agency. That is now law of the land in the state of Arizona. Arizona was the first state to do that statutorily. State of Florida did it by constitutional amendment. But in our view, the more states that take up this sort of legislation, the more state courts like Mississippi and Wisconsin that take up these cases to eliminate deference judicially, I think will be a very positive development in moving the federal courts and perhaps even the United States Supreme Court in the right direction on this issue.
Well, I can't hear you.
I think you're muted, Tim.
Sorry about that. This brings to mind what you just said. It brings to mind something that's in Peter's book, where he asks right out, does Congress care to preserve its own prerogatives? And it seems like a lot of the time, people who are elected to make the laws are perfectly happy to wash their hands of these responsibilities. And actually, Peter, you mentioned some of your colleagues at AEI. I remember a talk by Michael Grieva a couple years ago that I attended, where he was making the argument that states very often like to give away their power to the federal government because that allows them to evade responsibility. So do you think that we've seen any progress in the past 4 years, or do you think that we will see any progress in the next 4 years as far as Congress taking steps to put some real, strength into the separation of powers stuff that you and John have talked about?
No. Frankly, I do not see in Congress any movement in the direction of taking more responsibility. It's all taking less responsibility by handing over responsibility to the federal agencies. That's why when I began to think about how we could deal with this problem, I stumbled across, in effect, the non-delegation doctrine, which was completely dead. But I thought to myself, well, wait a minute now, if the courts would re-invoke this idea, then what would that mean? It would mean that Congress could not simply pass on all of these responsibilities to the agencies. And then I think it occurred also to a number of people in Congress, that a number of people on the court, that if they were going to cure this problem, which everyone in Washington recognizes, that Congress is evading its responsibilities by simply passing along powers to the courts, and that is multiplied by the case that we're just talking about, where deferrals occur all the time. And you can see in the federal courts, as the judges have become more conservative, they have begun to eat away a little bit at this structure, because there are two in that case. There are two steps. The first step is has Congress already decided this question? If so, there's nothing to do. We don't have to defer to the agency. And the second step is, well, if Congress hasn't decided the question, then we should defer. We should go on and decide the question. And normally what they have said is the agency has the power under these circumstances. But I think that the new way that even the courts are looking at this is to look at the first step and say, wait, Congress has already decided this question. We don't have to defer. We don't have to agree that the agency, we don't have to defer to the agency because Congress has already decided. Even when Congress has not actually said anything, that has been treated in some cases as a decision by Congress. The decision is you're not going to enter this area. It's decided under step one, so we don't go to step two and give you the deference that you're asking for. So I think that because so many new conservative justices are there, and conservative judges throughout the federal system are there and are probably interested in the non-delegation doctrine, we'll have something coming out of the federal government in the next few years. And of course, all our lawyers are very sensitive to this. Every lawyer knows now, if he's interested in constitutional law or not, he knows that there is a chance to pursue his client's position by invoking the non-delegation doctrine, so it won't be left out of briefs. It will become a part of briefs that on cases that are moving up through the federal system. So I'm optimistic about this, and with 6 conservatives on the Supreme Court, it's going to happen.
Yeah, and John and I were talking about something similar to that issue just recently. As you mentioned in your remarks, state constitutions often contain explicit separation of powers provisions, which the federal constitution does not. And courts in those states often interpret those as saying that the separation of powers at the state level must be stronger than it is at the federal level. And in fact, in some places like Arizona, for instance, we have this unique agency called the Corporation Commission that is in the state constitution. And that suggests that when the authors of the Arizona Constitution intended to create any kind of an exception or additional aspect or something to the separation of powers, they did it expressly. And that means that if they didn't do it expressly, courts should not allow that. Now, John, you and I were recently talking about something along these lines in, I think it was Wyoming, where the entire state regulatory code was allowed to lapse. And that kind of forced the legislature to act. Why don't you tell us a little bit about that?
I think it's probably no surprise to anybody that regulatory codes, just like statutory codes, are sort of a one-way ratchet. They always grow, they never shrink, and they continue to expand and encroach on more and more areas of our lives, meaning the government continues to expand and encroach on more and more areas of our lives without ever asking whether something is working, without ever asking maybe whether something can or ought to be repealed. So something interesting happened where out in the state of Idaho, I believe it was Idaho, they had a statutory provision that said the legislature has to reauthorize the entire regulatory code every year or every 2 years. Now, interestingly, there was some political infighting, and essentially what happened is the legislature said, we're not going to reauthorize the code. And when they did that, the entire regulatory code expired, all of it, all thousands of pages, which is extraordinary, because then at that point, it gave a clean slate and an opportunity to sort of start fresh. Now, of course, the drawback is that the executive was able to put in place through rulemaking process, et cetera, a number of rules that had previously existed, but resulted in a 31% reduction of the entire regulatory code, which is a pretty nice starting point. And Rhode Island, by the way, had a similar experience with this when they moved to an online format for their regulatory code. They let their paper version expire, and then you had to redo the rule if you wanted it to get put into the new system. And they had a very similar experience where about a third of the regulations were wiped off the books. So while this doesn't exactly address the structural problems that Peter and you, Tim, and me are kind of most concerned with, it's a really interesting way to wipe the slate, and this can be done statutorily as well in the states and perhaps even in the federal government.
Yes, well, the opposition at the federal level, I haven't seen it at the state level, but the opposition at the federal level, starting at the Supreme Court, is to say, if you adopt this non-delegation doctrine, you will immediately make unconstitutional all of the regulations of the federal government. And that's a Kagan argument, Justice Kagan, and it has penetrated. And so you hear a lot of that from law scholars now who are on the left and want to prevent any such action, like the non-delegation doctrine, that say, well, that'll just throw everything into chaos. I do not believe that will happen. The way that the courts work is on a fact pattern of various kinds that come up before them. And they make the decision based on some very complicated and specific facts. So if a non-delegation case comes before the court, the Supreme Court, They will make the decision on the basis of those very specific facts, and any other case that is dealing with the same issue, that is with non-delegation, would have to scale that fence to make it to the court and get a holding from the court. So everything will remain in place after the court makes any kind of non-delegation decision, unless it's far more made broadly applicable in some way, just like in, was it Idaho where that happened?
Yeah.
The Supreme Court will not do that, but they will set forth a kind of jurisprudence of non-delegation and explain what non-delegation is about and why it is essential for the federal courts to be to observe it in some way, but it certainly doesn't immediately change the status of all the regulations that are outstanding.
Yeah, and it's interesting that what your title you said you drew it from the Federalist Papers, Judicial Fortitude, and that of course kind of it seems to be the opposite of the theme of judicial restraint, which has for a very long time been sort of the slogan among conservative lawyers and judges. And
Right.
Ironically enough, judicial restraint was originally what Chevron was supposed to be about. The Chevron Non-Delegation Doctrine was supposed to be the idea that, well, courts shouldn't be in business, we should defer to what agencies do so as to be restrained. And now I think what we've seen, and as you said, is we've seen sort of a recognition that isn't good enough.
Yeah, absolutely. Interestingly, sort of the father of conservative legal doctrine, Scalia, Justice Scalia, was the one who was the strongest supporter of the Chevron doctrine. And one of the reasons I think he was such a strong supporter of the Chevron doctrine was his idea was also judicial restraint. So we can restrain ourselves. We don't have to interfere a lot with what is happening in the United States in legal matters. That's the right thing for us to do. But that results, unfortunately, in support for Chevron. And it wasn't until, I guess, 2018 with a case called City of Arlington, where Chief Justice Roberts said, we've got to change this Chevron system. And the next case that came up after that, strangely enough, and this is a little before his untimely death, Justice Scalia said, we've been ignoring the APA, the Administrative Procedure Act, because here's the language in the Administrative Procedure Act that says that the courts should decide all legal questions. And if the courts should decide all legal questions, then the administrative agency is not empowered to do that. So there is this court moves tremendously slowly, but they are moving in the direction of eliminating the Chevron decision in some way. That they won't overrule it. They will redefine it, and it's sort of maybe in the way I was talking about. And then they will proceed, I think, to take on the non-delegation question, because the two are very closely related.
Yeah, and to get back to what we were saying earlier about states, state courts tend to act more quickly than the federal Supreme Court. I think part of that is because the federal courts want to, in theory, they say they want to let state courts or lower courts develop ideas before they take them up. But also, and John, you and I have talked about this many times, how frustrating it is that state courts sometimes just seem, it's as if they take their marching orders from the federal courts when there's no basis for them to do so whatsoever. I mean, there's no reason, for instance, state courts should be copying the legal theories of federal courts talking about provisions of the federal law that don't necessarily even exist at the state level. The one that's before the Arizona Supreme Court right now, it's not an administrative law case, but it's kind of on the same point, is that this issue about searches and seizures without a warrant. And the Arizona Constitution's provisions regarding warrants it's completely different wording than the federal Fourth Amendment. The language is entirely different. The Arizona Constitution was written in 1910, and yet, never, despite these complete differences, Arizona state judges have often borrowed legal theories from the federal courts, interpreting a document that's well over a century older than the Arizona Constitution, when interpreting a provision that doesn't even have the same language. So, the kind of fortitude you're talking about is something we really need at the state level too. We need state judges to start paying attention to their own state constitutions, their own state legal history, and their own constitutional provisions.
Yeah, that's right. And the judges have, in many cases, been told or believe that because they're unelected, they should not move into these areas and make these kinds of decisions. But in fact, they were elected by the framers. They were elected by the framers to make sure that we didn't move out of the constitutional system. And that's what these non-delegation cases are about.
I'm so glad you said that, because it drives me a little bit crazy when I hear the phrase unelected federal judges, or undemocratic federal judges, when a lot of people, perhaps in the recent elections, probably most people voted for the president because of who the president said he was going to put on the courts. And so these are not undemocratic officials. They're certainly more democratic than, for instance, the Secretary of State, who is also nominated by the president and confirmed by the Senate in the same way that federal judges are. And nobody goes around saying, oh, that undemocratic, unelected Secretary of State, he lacks democratic legitimacy. Nobody says that. So the federal courts have been delegated power by the people of the United States to enforce the Constitution. And obviously, at the state level, a lot of judges just are outright elected or face retention elections. So there's state judges not to show that kind of fortitude. John, what do you think that we can do to try and encourage state judges to take interest and have that kind of fortitude at backbone?
Well, I mean, part of it, and that's why I like the title of Peter's book so much, Judicial Fortitude. That is what is required.
Right.
President Trump famously said when he put out his Supreme Court list, he wants to appoint judges that are not weak. And I think that is going to be, to the extent that judges are appointed by state executives as well, that mentality to appoint judges, not that will make policy from the bench, because of course that is improper, but judges will not be afraid to take on their role as a separate and co-equal branch and to restrain the other branches when the other branches have acted outside of their constitutional authority. This is, of course, the difference between judicial restraint or judicial abdication, which is the worst form of judicial restraint, and judicial engagement. Of course, the former being undesirable and the latter being desirable. So part of it will be how the judges get into place, the right judges into place. Part of it, though, will be bringing the right cases. As Peter mentioned, the judges are not proactive, they're reactive, and it requires the right cases, right setbacks to get in front of them for them to make the right decisions and to frankly give them as much of a reason to make the right decisions, so that to the extent they have fortitude, they're able to exercise it in a way that is reasonable and meaningful in the right case.
Yeah.
And having both of us, and I don't know about you, Pierre, if you've done this, but we represented people in administrative agency hearings, and when you go through those processes, the rules of procedure and the rules of evidence that apply in a courtroom do not apply. But there are some exceptions, but for the most part, they don't apply at these state administrative agency hearings. So what ends up happening is a person is alleged to have violated the Clean Water Act, whatever it might be. And what happens is you don't get arrested for that and taken to court. What happens is you get an order from a single official at the Environmental Protection Agency commands you to do something in order to come in compliance with the law. And until recently, you were not given an opportunity to challenge that order. You had to either comply or refused to comply and risk punishment. And then when they came out for punishment, at that point, you could seek a hearing. And it wasn't a court hearing. It's a hearing in front of the agency itself, which is, of course, the same group of bureaucrats that charged you with it. And they can use hearsay against you. They can use all sorts of other kinds of evidence that a courtroom you would not be allowed to use. And then if you appeal that, once you lose in the hearing, of course, you're going to lose at that hearing because the prosecutor is paying the judge. So when you lose at the agency hearing, you appeal to an actual courtroom. The judge at that point is not allowed to reconsider the evidence or to consider new evidence. Now, that's not always true, but it's usually the case. It's certainly true, for instance, in California, where if you appeal an administrative agency decision to a California state trial court, the judge is required to rely exclusively on the evidence that the agency had, even if it's pointless, misleading or hearsay. An example, I worked on a case, this is almost like 20 years ago now, where the question was, it was before the California Coastal Commission, which is the most aggressively anti-property rights institution on the West Coast. And single-handedly strangled development of 800 miles of California coastline for an entire generation, almost entirely at the behest of a single official, which is the executive director of the California Coastal Commission. Well, in this, the issue was the value of certain property on the beach in Monterey County. Those of you who don't know, Monterey County is in Northern California. It's rocky coastline. It's cold. It's foggy, kind of San Francisco-like. It's very beautiful. It's where Pebble Beach Golf Course is, but it's not the kind of place that you would go sunbathing in a bikini. So the question in that case was, what's the value of beach land? Well, it turns out there really isn't any good way of estimating that. So the Coastal Commission relied on two loose opinions from economists about the value of beachfront land in Orange County and Los Angeles County, which are hundreds of miles away in sunny Southern California. So we objected, of course, to the use of this information, but this supposed evidence in front of the agency. Of course, they ignored us, and when you appeal that, you can't dispute that. You can't question that in front of a judge. Yeah. So really, in process. We're really sorry for the rant, but it bothers me 20 years later.
Well, there are these problems with in the administrative agencies, and the adjudication there is even a tougher question. I'm just talking about the making of the regulations, but once you get into adjudication, then you get things that are highly suspect under the constitutional system and have never been seriously considered by the federal courts. I think we may be entering a time when the federal courts will begin to look more closely at this, because if you're starting to talk about our living under a constitutional system, and if you don't just think about it as, well, this is a democracy, but it's not a democracy, it is a democratic republic under a constitutional system, then you've got to honor the constitutional system, as well as the idea that everyone is entitled to a fair trial and so forth. And judges who will have that idea, judges who are strict constructionists, if you will, or originalists, should see themselves operating that way, and making decisions based on what the Constitution as a whole is requiring, and not just what a single agency or a state law might seem to be putting into place. So I'm optimistic that a new way of looking at litigation and looking at Constitution and looking at the separation of powers and how important the courts are in that will come out of this non-delegation idea.
And I would add, to kind of put a point on what Peter's primary concern here is, these enforcement actions that come out of administrative agencies are often so absurd, are often decided so wrongly and so in favor of the agency, that it then points right back to the original problem, which is, well, why are they exercising this power in the first instance? It never should have been. It wasn't delegated. If it was, it shouldn't have been delegated. I'll give you a really quick example. The state of Arizona passed a wonderful bill dealing with occupational licensing. So, of course, an occupational license is a permission slip to work. And if you move around from different states, you got to get a new occupational license, even if you held an occupational license previously. So Arizona passed a great bill. It said, look, if you hold an occupational license in another state, you've held it for a year, there's no complaints against you, you can come to Arizona and that license is going to be recognized effectively. Great bill, law of the land. It reduces this mobility problem with occupational licensing. But, of course, as people were applying for these licenses, most administrative agencies were firm, but there were some outliers. In Arizona, the Board of Psychologist Examiners looked at the new law, and even though it said nothing about the duration of time that a resident has lived in Arizona, they said, well, we think that this law only applies to new residents, not a resident who has lived in Arizona for any length of time, and they denied a series of licenses on this basis. So, you know, of course, we challenged that, but I say that to make a couple points. One, it underlines Peter's point. Let's not delegate it in the first place. Two, though, even when you put in strong prophylactic measures like this or good policy like this, and many states are now following Arizona's lead and adopting this similar policy throughout the country, it still is going to require enforcement by active litigators and by a judiciary who's going to hold the agencies accountable. And then, of course, we'll have a body of stories to say, and oh, by the way, here's why we need to hold them accountable, because when you don't, they do all of these crazy things.
Yeah. And, you know, if we are indeed on the cusp, and it certainly looks that way, of a Biden administration, I think at the federal level at least, these concerns are definitely at the forefront. I sent you guys just last night, I sent both of you this article that just appeared in the City Journal by James Copeland, and he's concerned, the title of the article is "The Winner, It Might Be the Administrative State," and he's concerned that in the event of a Biden presidency with a Republican Senate, that you and I probably would say, well, that's good to have the checks and balances at least, and that way it prevents anybody from doing something too crazy too quickly, all that sort of thing. But he's concerned that what will happen is a true stalemate will leave the decision-making in the hands of these bureaucratic agencies. He says the principal battlegrounds for shifting policy will fall back into the realm of the unelected. Is that a concern that you have, Peter, in the coming 4 years?
Sure. Yeah. I mean, if you can think about who is the most influential person who comes before the Supreme Court of the United States, and it's the Solicitor General of the United States. And in a Biden administration, he will be a much different person from the person who would come to before the court in a Republican administration, or basically in a Trump administration. So in a Biden administration will put things off for a long time because they will come into court with a position that says don't invoke these new ideas. Follow what the administrative agencies have always done. That's what the law has been for many, many years. So there's no reason to change it. And I don't know how this current court will react to that. I hope that they will stand up and say, this is not possible. This is not following our Constitution. But it makes a difference when a major lawyer representing an entire government steps before the court and speaks for that government.
You know, I wonder, Peter, and maybe this is just a bright line flip side of that, but if the country were to get a Biden administration, you may have on the other side of that administrative overreach that has not existed over the last few years, and under the newly constituted court that you described, where 5 probably 6 justices are going to be very skeptical of administrative overreach. Perhaps it will create opportunities to get the right fact pattern in front of the court from a Biden administrative agency.
That could be right. That's a more optimistic view of it. It takes
John
a
is an optimist. That's his role, is to see the bright side of whatever the situation is.
I have to balance of course.
It does take a while for a lot of these cases to bubble up to the Supreme Court. And so if we have a Biden administration, and it's not clear yet that we will, but if we do have a Biden administration, they will start making much more aggressive moves at the administrative level. And those cases will then come up toward the Supreme Court. And unless the Supreme Court wants to reach down and pick it out of whatever is down there at the lower court level, and because it's a good case to decide on non-delegation grounds, unless that'll happen, it'll be 4 years before a case actually gets to the court. And maybe by that time there won't be a Biden administration. Of course, it could be a Harris administration.
First thought. Well, thank you.
Nothing optimistic about that. Go ahead.
Thank you both, gentlemen, for a really stimulating and interesting conversation about the administrative agencies, the risk that they pose to our constitutional system, both at the federal and the state level. And thank you all of you viewers for joining us for this conversation. If you want to learn more about this issue, first of all, I recommend to you all Mr. Wallison's book, Judicial Fortitude. You can get it on Amazon. And then check out our website. Our blog is In Defense of Liberty, all one word, .blog. And our website, of course, is goldwaterinstitute.org to follow up on how we're working to try and rescue liberty from the grasp of these administrative agencies. Thanks again for joining us, and we hope to see you next time.
My pleasure. Thank you, guys.
Thanks, Tim.